What better place to spend a rainy Wednesday morning than with Steve Elville and me on the Elville webinar series? I'm Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be your moderator today. I'm pleased to share with you our topic, which is what families need to know about planning for a loved one with special needs. Presented by the aforementioned Managing Principal and Lead Attorney of Elville & Associates, Stephen Elville. And you're in the right place for high-level legal education today. We encourage you general questions, so please note them in the questions panel or chat on your screen, and we'll pause periodically throughout to address them. As always, your questions add value and they help others learn, so please pose your questions at any time. And yesterday by email, you received presentation slides that Steve will be referencing, so be sure to print those out and you can look at those anytime throughout the presentation. These materials are also available in the section marked handouts on your screen to download at this time. We have several professionals on today's webinar, so welcome and thank you for being here. 1.5 continuing education hours are available for most everyone in attendance. So if I don't have your ID number or accreditation yet and you'd like CE hours for attending, please send that over to me so I can submit them for approval along with sending out certificates. And everyone will also receive a post-webinar feedback email right after the presentation. And we ask that you please take just a minute or two to fill out this very brief survey and offer us your valuable feedback about the presentation. And we read and consider and value every comment that you have to share with us. And here at Elville & Associates, we're always here as a resource for your family and you. New planning needs that need to be addressed, outdated documents that need to be reviewed, or perhaps another matter, Steve and our team are here to advise and counsel you through those processes. So I'd like to offer just a brief introduction and share a bit about our firm. We have a really quick poll to learn what's brought you here today, and we're going to jump right into the presentation. So Elville & Associates, founded in 2010 here in Columbia by Stephen Elville. We have several different practice areas that we focus on here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 9 attorneys, 12 staff members in 5 locations. Steve and I are coming to you live from the Columbia Gateway Community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we focus on education a lot here at Elville & Associates. We do that in many, many ways. One is through our planning processes with our clients, and we have different programs to suit all families and individuals. Also by way of our educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program. We are one of only a couple firms in Maryland to have a client care program accredited by the Client Care Academy in Boston. We're looking forward to our what's supposed to be our first quarter client care education program that was snowed out for the first couple times, but it's coming up on April 13th over at Anne Arundel Community College, and we're looking forward to hosting our members in a couple Saturdays from now. We also focus on the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. Just a bit about Steve. His work as an attorney for the past 23 years has been centered in elder law, special needs planning, and estate planning. A member of many different national membership and professional organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys, among many others. He works to bring peace of mind to clients by offering solutions to their needs through counseling, client education, and the use of leading edge legal technical knowledge. Steve is a very seasoned speaker and presenter, each year offering many webinars, workshops for businesses and their employees, conferences, and continuing education events. Just last week, we were at the Brain Injury Association of Maryland annual conference. That was at least our 10th consecutive year there. It was just a wonderful event. If you're not familiar with the Brain Injury Association of Maryland, I highly encourage you to check them out, and we can make some connections for you there with the executive director, Brian Pugh, and the assistant director there, Caitlin Starr. They're wonderful people. Also, Steve was named to the Maryland Super Lawyers list for a 9th time and 8th consecutive year in 2024. He had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014. I'm very fortunate to be the executive director of. If If you'd like to learn more about the Elville Center, please reach out to me directly. I would be very happy to share our story with you when we have just a bit more time. For now, we're going to talk a little bit about special needs planning, a very important topic in and of itself. And we're going to run just a real quick poll to learn what has brought you here today. And the question is, to get to know our audience, please tell us what has brought you to today's webinar. And your choices are: 1, I need to set up planning for a loved one with special needs. 2, I have planning in place, but it needs to be revisited. 3, I'm a financial advisor here to learn to benefit my clients. And 4, I'm an interested family member here to gather information. All great reasons to be here, and whatever it is, we appreciate you being here with us today. We'll give it just about 15 seconds for those that want to participate. And 5, 4, 3, 2, 1. Okay, Steve, we have 46% saying I need to set up planning for a loved one with special needs. 23% say I have planning in place, but it needs to be revisited. And today is 0% say I'm a financial advisor here to learn to benefit my clients. I do know we have some advisors, maybe they're a bit shy today on our presentation. And 29% say I'm an interested family member here to gather information. So Steve, there you go. Thanks for participating, and I'll make you the presenter.
Thank you, Jeff. And I'm just going to get my screen organized here very quickly because it just appears that I didn't really get my presentation where it should have been. There we go. And thank you for that wonderful introduction, Jeff. And good morning, everyone. Right. And Jeff, I just want to point out that I have my happy cup again this morning. I was able to find it, and I am smiling this morning along with my happy cup, and I'm looking outside, and despite the rain, I see nothing but flowers and buds on the tree. So just a wonderful day, even though we are still inching into spring. Good morning, everyone, and thank you for your commitment to learning and being here today. All those wonderful things Jeff said about me or Elville and Associates, I could not do without people like Jeff and our associates and attorneys and staff here at Elville and Associates, and you being able to give your time and effort to support our webinar series. For those of you who are advisors or CPAs that have been collaborative with us, those of you who are clients or prospective clients and special guests, welcome. And I just want to take off real quickly here because I want to be efficient this morning. I want to value your time and make sure that we cover the things we need to cover. Many of you don't have a lot of time, and that's one of the things we want to honor and make sure that we're aware of this morning, that your time is valuable. Jeff talked about why are you here today? Well, you were very honest and you said, hey, I'm here for various reasons. Now I want to ask you one other question for a minute. I want to ask you, what would it take for you to get organized to be able to do the kind of planning that you want to do? Here's why I'm asking that question. Years ago, I was asked by a financial advisor who I have a lot of respect for. He said, Steve, you do a great job educating clients. Elville and Associates does a great job of caring for clients, hopefully, and educating clients. But he said, are the clients organized? Is the client really ready to be organized, not just to be educated, but to be organized? So I wanted to take just a real quick minute, and not only ask yourself, why are you here? What is my purpose in being here? But so I can get the most out of this, if I could glean information today, and by the way, this is a mini master class, so to speak, on special needs planning. So we're going to cover a lot of things fairly quickly and be efficient. We will answer your questions, but I also want you to keep in mind, what would it take for me to get organized? Many of us are running crazily in our lives, especially families with loved ones with special needs. Your time is valuable and you've got a lot going. What would it take for you to be focused and organized? Let's take a minute on that, Jeff, and I'm timing it right now. Think about your life, your patterns, your free time, your focus. What are you able to focus on? I know for me, if I can't focus on something, I'm not going to be able to push it forward. I sometimes fool myself into thinking that I can accomplish something or get from point A to point B and juggle 5 or 10 or 15 things all at the same time. But when I look at it in the final analysis, I'm only able to get things moving forward if I'm focused. So think about this. We've got about 30 more seconds. What would it take to get focused on this, to get from where you are now to the finish line, and to be able to think through all of the issues? We're going to lay out something for you here this morning so that you can get from point A to point B theoretically. And in the educational process, you can get, and through the legal process, you can get from where you want to go to where you want to be, or you are to where you want to be. But I want you to think through the obstacles that you may have in your own life as we go through and get started here. This is not legal education, legal advice. It's legal education only, because we are not in an attorney-client relationship here on this webinar, but we can be. And this is really high-level advice as far as educational type of high-level counseling on this webinar, but not legal advice in the true sense. So just keep this in mind as we go through. When we think about planning for a loved one with special needs, we're really thinking about how can we enhance the quality of this person's life. Now, special needs planning can be very fundamental, and we do have to have the basic structure correct. There are times when we see special needs plans that are out there, existing ones. Some of them are very simple, and they are on the right path, they're on the right structure. Sometimes we see special needs plans that are incorrect. There's a misunderstanding about the basic structure. So as long as we have a basic structure, we can keep it simple, or we can build a lot of features onto that structure to enhance the quality of someone's life. So it's not that a simple special needs plan is wrong as long as it's on the right structure. It's really how much more could we really do for the person who is the beneficiary of this trust to enhance their quality of life. So that's what I want you to think about, is we have to have the fundamentally correct structure, and then we can build as much or as little as we want to enhance that person's life. And of course, the fundamentals of the whole type of planning we're talking about here, special needs planning, is to really create a world for the person. In addition, generally speaking, most of the time, in addition to the world of public benefits, to create a world for the person where they have additional support, additional enhancement, and so forth of their life. So there are several benefits. We'll go through them quickly. Financial security, leveraging means-tested public benefits, which most people that are interested in doing special needs planning, their loved one is on public benefits of some kind. Not always, not always. Sometimes wealthier individuals or a person who is the beneficiary of a trust that is substantially funded would not need public benefits, but generally these are the benefits of planning. We want to put a team into place, not just a lawyer who's educating you or an advocate. We want to have a CPA, a financial advisor, a lawyer who understands special needs planning, and maybe a life insurance professional, and in addition, an advocate. We want to talk about appropriate housing, and we just mentioned advocacy. We want to have robust advocacy. We want to plan for the caregiving needs in the future that may need to take place, and you will know that through the planning process and your own experience, how much care is likely to be needed in the future. We want the entire family, grandparents, siblings, and others who may support the loved one with disabilities. We want them to be involved in the planning to whatever extent it's practical. We want to protect the beneficiary from predators, and fraud and abuse. And in the whole process, we would generally be able to preserve assets for others, depending on the situation. So I'm going to be redundant as we go through here. I'm going to hit you hard with the fundamentals so that you have this kind of masterclass of the fundamentals, but we're going to mention certain things more than once. Having the right team of advisors, making sure that we have an advisory team that I just described, making sure we've thought about advocacy, making sure we have flexibility. And that's something that you're probably not thinking about intuitively. But from an estate planning or special needs planning legal point of view, we want to construct a plan that has flexibility. One of the ways to do that is through a trust protector, or in some circles, this would be called a trust advisor. And I will talk about that more later as we go through. So let's talk about how to create an effective plan. Well, to have a purpose, we talked about that, to have a clear mind so that you can focus on this in your busy life, your chaotic life perhaps, and have a vision. So we want to have the time to think. We want to think about several things, not only the things I'm talking about, but the things that really worry you, the things that you're dealing with every day in your day-to-day life that only you know that you're dealing with. Giving you the time to think, where will your loved one live? Will it be in a house you provide or a condo? Will it be in group housing? These are very, very important things to be thinking about, not just once at the time of planning, but throughout the rest of your life. What type of care will be required? Is my loved one able to sign documents on their own, like they have a high functionality and capacity? They could sign powers of attorney and advance directives, or do they need a guardian? Who else will be involved? Who are the players that are in your life? Should we have outside resources, family members taking care of some of these issues and be in certain roles? What kind of lifestyle is desired? That really gets back to the issue of how conservative do we want the special needs trust to be, or how liberal do we want it to be, depending on how much funding there's going to be into the trust. And we're going to talk about that. What are the future challenges that could happen? And this is really getting into the issue of building in flexibility, layers of protection, layers of flexibility. And as I said at the beginning, really understanding our purpose and process. Process is important so that none of these things are left out. Now, with that said, many of you, again, are overwhelmed, and we could keep it relatively simple. But if we could build from a solid platform, we could keep it as simple as you want, or build on other features of a customized special needs plan. One of those things you can do is creating a memorandum. So you can create your own memorandum, or we're happy to give you a sample of a memorandum. But this memorandum of intent is something that could be in the trust itself. It could be attached to the trust, which is what I recommend. And this is a guide to the future, a guide about the particular needs of your loved one. And it's very personal to you and to them. So think of millions of trusts out there. None of them have a memorandum of intent, very few. And you can kind of separate yourself from the pack of how good or how broad you did your planning by using a memorandum of intent. It takes a lot of commitment, takes a lot of focus, but you can do it if you want to make your special needs plan stand out. So we want to be thinking about these things. We want to be thinking about future budgets. This is very difficult to do. So what do we want to do? We want to use advisors. We want to use our resources, our professional advisors, such as financial advisors, CPAs, projecting, knowing what their resources are that they can help you with. I know many of you want to have relationships with financial advisors and CPAs, but you haven't had time to strike out and find those people. And for example, we have a big shortage of CPAs right now in this country, so finding a good CPA is not easy to do. We are here to help you find resources that can advise you about how to think in terms of monthly budgets, and this old-fashioned spreadsheet is something that you could easily find on the internet or use other financial advisor resources. Many times financial advisors are going to help fund special needs plans with life insurance. If you haven't already done that, or if you haven't thought about life insurance as a funding tool, we can help you with that as well. Thinking about our loved one's capacity, we talked about this just a few minutes ago. As part of the overall thought process, how are we going to deal with decision making for our loved one with disabilities? Can they, exercise self-determination with their own power of attorney documents? Will they need a guardian? I know we counsel people on this subject almost every day at Elville and Associates. Will we have supported decision making for this person, whether they are under guardianship or not? So these are big issues that are part of the broader picture. Now, trustees are going to be critical. Trustee selection is critical. For those of you who like to watch our webinars, we have a trustee selection workshop, and that's one of the biggest issues today is who's going to be the trustee of a trust, whether it's a special needs trust or not. Let's get into the issue of understanding public benefits and how it's important to have a trustee that understands these things. When we think of public benefits, we want to talk about the quintessential things that define public benefits. Many of you on this webinar have a loved one who is on SSI. They receive supplemental security income benefits, and some of you have loved ones that are disabled that receive Social Security disability benefits, either on their work record or on your work record, because they were disabled prior to 22 years of age, and they are disabled adult children. So this chart illustrates, we're going to focus on the two, the one in the middle and the one on the left. SSI results in medical assistance, which is Maryland's term for Medicaid. That's means tested, can't have more than $2,000 in the person's name. One of our associates pointed out to me just yesterday that Social Security has a new rule now that the purchase of food will not be considered as something that is prohibited from a special needs trust. So that was really good. I just wanted to throw that in. But a person who's on SSI will eventually, if they are a disabled adult child, they will switch to SSDI upon your retirement or upon your death. And we're going to see a slide on that. And when we go to the right here and we look at HUD benefits or Section 8 benefits, that is a subject in and of itself that's beyond today's program. But I just want to point out that most trustees do not understand this simple chart. So I would recommend a book, and Jeff, I'm just going to digress for a second and recommend the book that I particularly think is a really great book. It's called How to Administer the California Special Needs Trust. How to Administer the California Special Needs Trust by Kevin Urbash. He's a person I really admire who is the past or maybe even current president of the Academy of Special Needs Planners. He's out in San Francisco. So we're not talking about California, Maryland. We're talking about the state of California. But don't be dissuaded from getting the book if you would like to read a really good book about how trustees can understand all of these things. And as you think about yourself as a trustee or others as potential trustees in the future, I would highly recommend this book. For anyone who becomes a client here at Elville & Associates, we provide this book, and we're happy to get it for you as a gift from us. So just know that this book is on Amazon, but also we always make sure that we have copies of this book available. So understanding these things sometimes is not as easy as just listening to a webinar sometimes. It is going to take a little bit of series of repetition to understand public benefits, and that's what our trustees need to do. So this is the SSI test. We're not going to spend a lot of time on that today. You see the definitions of disability. This is for your records and your ability to look at it later. These are the resource tests. Now, little nuggets in here. Many people don't realize that if you have a loved one on SSI, that they still could own a home, they still can own an automobile and so forth. Now, that's not to say that they should own those. Most of the time, a person with disabilities on SSI would not own a home in their own name, but it is possible, and that is not excluded. Excuse me, it's not considered an available resource. It is exempt, is what I'm trying to say. So these are the things to just start educating yourself about if you have not done this, or educating your trustee. Now, SSI is to pay for food and shelter. Okay, in 2024, the benefit rate is $9.43 a month. In some states, there is a supplement to the SSI rate. So depending on how much money is left into a special needs trust may alter your thought process about how important or how less important SSI is. But I will just say, generally speaking, for the vast majority of people, even though SSI is not very much, it adds up over a long period of time, and it is a very important thing. And by definition, the beneficiary is on medical assistance. Your trustee needs to understand the concepts of unearned, and earned income. This can cause an SSI beneficiary to have their benefit reduced to zero if they're making too much income. In-kind maintenance and support payments, we're going to see this coming up here, and what is deemed to be income and what isn't. These fundamental things are reasons to read the book I just mentioned, or to come in for further discussion about these issues, or to educate your trustee in family meetings if the trustee is either an ancillary family member or someone outside the family. SSDI eligibility, we're not going to spend a lot of time on this. Just know that what I mentioned earlier is that if a person is a disabled adult child prior to age 22, they have been disabled prior to that young age, they will be considered to be a disabled adult child who will get a benefit from their parents' work record. And if we review the chart that I displayed a few minutes ago, you'll see that that child will now move into that middle category upon the retirement or death of their parent, and they will receive, in most cases, medical assistance, Medicare, which is not means tested, and they will also be in the waiver system or whatever other means tested benefit that they have. So if a person moves into that second category, they still need the protection of a special needs trust if they are on means tested benefits, which most people are in that circumstance. We're not going to review a lot about Medicaid and Medicare in general. Here are some slides just for your benefit. Housing, though, we're going to spend just a moment on this. Housing, these are special considerations. Should a special needs trust own the house for my loved one? What if my loved one is in Section 8 or HUD housing? What is the effect on my loved one? There are certain effects that we have to be worried about. As you think through housing, this is one of the things that's most concerning to parents. And we want to make sure that in the counseling process that we've thought about, to whatever extent that we can, and it's very difficult to think through these issues. How much money will we have when we pass away? Very, very difficult to know. What kind of residence should we leave for our loved one? Should we leave that in the discretion of the trustee? All of these things are huge considerations that we try to do our best to get our minds around. Sometimes it's very clear, sometimes it isn't. Sometimes it will become more clear as time goes by. Jeff, I'm going to take a 1-minute pause here just to see if there's any questions. I know I'm moving a little quicker than normal because we want to be efficient here this morning.
Well, thanks, Steve. No questions as of yet for our attendees. Don't be shy in posing those questions to Steve.
All righty. We have now the portion of our presentation that most of you have attended for today, and that is special needs trusts themselves. So let's talk about the different kinds of trusts. Our special needs trusts come in different varieties. So for those of you who have a tablet or a pad of paper or your phone, whatever you may be making notes on, I want you to make notes about this. The first column, left to right, is the third-party trust. This is something that we would call a supplemental needs trust. A third-party supplemental needs trust. That's a mouthful. Anyone can establish this for a beneficiary. Any third party, Uncle Sam says, and the states say, if this person created a trust for the benefit of a disabled person and that person left money to that trust, coming from point A to point B, straight to the trust, the disabled person never received the money from point A to point B. Now that money is exempt. It is not considered to be the money or the funds of the person with disabilities, assuming the trust was correctly drafted. It's a discretionary trust, which we'll talk about in a few minutes. So the third-party trust has no payback to the state of Maryland or any other state. It is exempt under the law, and that is the bread and butter of how you should plan for your loved one with disabilities. The third-party supplemental needs trust, most of the time, that is going to be where we are. And that illustrates that you can't really do good special needs planning if you don't do your own estate planning. So you have to take care of your own planning. And in that planning, you would provide for the further planning for the loved one with disabilities, the third-party trust. And don't forget, in your own planning, you're going to do your own incapacity planning. What happens if I become disabled? I've had several clients just in the last year live over 100. And so people are living a long time. If you become disabled, remember, who is going to take care of your loved one that has always lived with you, let's say, or always depended on you? And now your power of attorney document could be the most important of all the documents. So don't forget, taking care of yourself first is part of taking care of your loved one with disabilities. As we go to the next two columns, left to right, we see the D4A and the D4C trust. Now, some of you may say, where did that come from? Well, that came from the United States Code. For those of you making notes, it doesn't really matter for today's presentation, but that reference is the United States Code, 42 USC 1396P, 1396P D4A. That means that if your loved one did receive money directly in a, God forbid, a birth injury, an auto accident, a train accident, they've received an inheritance from someone directly. Remember, we talked about the extended family members needing to be on the same page as you? Well, what if they weren't? And what if they kind of neglected to think through what they were doing and they left funds directly to your loved one with disabilities? Well, now, if that person is under 65 years old, we can put that money in a first-party trust. The person who's disabled has received the money. Now, that has to be taken out of their name, either the parent, grandparent, guardian, court, or the disabled person themselves if they are of higher capacity. They can establish this trust and the money can be moved to that trust. So that is a godsend. That's a wonderful thing. The problem is, some of you will think, is that it's got a payback. So this is a trust that has to be paid back to the state or states that supported your loved one. This is also the same kind of trust that, again, holds large settlements from lawsuits where people are injured. It also is the kind of trust that is used for military veterans who assign their military pensions for the benefit of their loved ones who are disabled, who are going to survive them. The D4C trust is a pooled trust, such as the Arc of Northern Virginia and other pools for disabled people. These trusts can be established for someone who's under 65 or over 65, and these are less expensive ways to go for, let's say, smaller amounts of money, or where someone doesn't want to spend a lot of money getting a D4A trust established for various reasons. So these are the things to kind of get your mind around. The fundamental tool for estate planning is the third-party supplemental need trust that you can create or anyone else can create in your family. The D4A and D4C trusts are tools where our loved one is receiving money they should not have in their own name because it will eliminate their benefits. So as I just mentioned, this is for your information. The third-party trust is the best method. If we had our choice, this is how we would do it. It's very flexible. It has no payback. And God forbid, if your loved one were to die and there's still money in the trust, it can go wherever you decide that that money should go, to other family members, to charity that may have supported your loved one. So the government is now allowing that, thank goodness, that we can leave money to charities from third-party trust with no consequences. Now, we've talked about the ideal ways to plan. We've talked about, the first-party trust and what happens with that. But let's talk about the other arrangements that you'll look at yourself and say, okay, did we do this? Or did anyone else I know do this? So we don't want an outright inheritance. We don't want to just leave money to someone who's on benefits. That's a disaster. We know that. And there would be a loss of SSI or Medicaid or means-tested benefits. We don't want that. But remember, if that happens, we have the first-party trust that we can use, and that is comforting, hopefully, to you. What if, as I mentioned very early on in the presentation, what if someone established the wrong kind of trust? They thought they had a special needs or supplemental needs trust, but it really was a general needs trust. It didn't meet the definition of a discretionary trust. It was actually what we will call a support trust. And we know that a support trust will disqualify our loved one from benefits. So what if we have the wrong trust? Well, now there's going to be a loss of SSI, a loss of the waiver programs, a loss of Medicaid. Now, this is a bit of a digression. I'm only going to do this for 1 minute. There is something that should give you further comfort, and that is that Maryland just stepped up to the plate in October of 2023, and our new decanting law went into place. That just means that if there is a trust that's not appropriate, there's a very good chance that that trust can be changed to the appropriate trust for your loved one. So please have confidence that our Maryland laws are better, they're getting better and better, and we have lots of flexibility, especially for taking care of people with disabilities. Disinheritance, don't leave any money for my loved one. Well, that could be bad, right? That could be bad, and we don't want to do that. You've seen that, I've seen that. How can that play out? Well, let's look at these bullet points. Well, I disinherited my loved one with disabilities. I gave the money to someone else. I gave the money to their sibling. Well, God forbid that sibling could have creditors, and the creditors got that money. Or, God forbid, the sibling passed away, and their estate left the money to someone else who has no obligation to use it for the benefit of your loved one. What if the sibling got divorced and lost that money to a divorcing spouse? Or what if you left the money to a sibling of your loved one with disabilities and they changed their mind and didn't want to take care of their loved one anymore, but their sibling? These things can all happen. Another couple of things are, it could be lost to the claim of the IRS. What if the person owed taxes and so forth? So these are things that we want to avoid. They can be very problematic. Please don't make these mistakes. We do another webinar called The 10 Mistakes That People Make Doing Special Needs Planning, so you're welcome to review that as well. So third-party trusts, these third-party supplemental needs trusts, we should say, they hold the money of another person for the benefit of our loved one with disabilities. This is the bread and butter. There's no payback requirements. It can be revocable during your life, even though many of us, when we were young lawyers, we were told to draft these trusts as irrevocable trusts. Well, we don't have to do that. These are revocable if we want them to be, and they only become irrevocable at the time of our deaths or some other event. We're moving along really quickly, so I hope you're following me. Choosing a trustee is important. It is maybe the most important thing, other than making sure that our trust is on the right framework. It's a discretionary trust. Well, who should be the trustee? Should it be a family member? Should it be a professional? I will say that over the years, I've seen a change in this. What I'm seeing now is a trend, and I think the whole country, as far as special needs planning, is seeing the trend that families are many times looking to professionals to be the trustees and looking to the family members to be trust protectors or advocates. So this is going to be a learning process or discussion process or discovery process for you as you try to decide, how should I structure trustees for a special needs or supplemental needs trust? And all of these factors come into play. Now, we talked about building in flexibility. Again, if we have the right framework, we can add on things to it. And I strongly recommend that you do, especially a trust protector, which we'll talk about here in just a second. Let's talk about a trust advisory committee. How many of you, have a loved one that is maybe not so easy to take care of, maybe not so agreeable? Many of you have disabled loved ones who are just a joy, and they are easy to get along with. They're not going to have a lot of big issues, but some of you have issues with loved ones. It could be mental health related. It could be other issues. And a trust advisory committee could be a great feature for your trust to tell the trustee that they're not alone. Hey, trustee, remember, you should read the trust, know what its provisions are, know about public benefits, know that you can ask for help. You can hire professionals. And one of those things that you can ask for is the advice of a committee of people. It could be advocates, coordinators, physicians, social workers that can help advise you at a time of crisis. Hopefully that'll never actually happen. A trust protector is a special fiduciary. It's been in Maryland law for about, I guess, 10 years now, since about 2014. Nationwide, trust protectors have been in the law, I'd say, for 20 to 25 years. This is a special fiduciary who has certain authority to give you, and it's not required to use a trust protector, but I highly recommend it, give you the comfort of knowing that there's flexibility in the plan. If a trustee is not doing a good job, a trustee is ill, a trustee has just, heaven forbid, caused your child to lose their benefits, that trustee could be held accountable or removed. The trust protector would have the authority to review an accounting on an annual basis or to make administrative changes to the trust. When we put the proper third-party trust in place, sometimes the laws change, sometimes the trust has to be amended during your lifetime. But what happens after your death when the trust is irrevocable and it has to be amended? So there needs to be flexibility built in. And even though the trust protector is not required, I would say a good rule of thumb would be about 98 out of 100 people in our firm who do special needs planning would use a trust protector. So I highly recommend you learn more about this concept and begin to try to embrace it. As you choose trustees, you're also going to want to think in terms of, who is my trust protector? Now, just another 1-minute digression. Historically, trust protectors would be independent persons, such as a friend of yours, or your lawyer, or your CPA, or someone from your church. Nowadays, we're seeing a lot of trust protectors in special needs planning. And when I say trust protectors, I'm really kind of saying advocates at the same time, flexible advocates. These are people who many times will be family members, even though theoretically a trust protector should be an arm's length independent person so that there's no conflict. But many times in special needs planning, it is a family member. This is what I would say is the current view of what a modern supplemental needs trust looks like. We've got trustees, trust protectors, able account provisions that the trust could fund an able account, advocacy provisions. In a perfect world, you would have created a memorandum of intent. There would be a trust advisory committee provision or not, and special retirement plan provisions, such as the fact that we're recognizing that your loved one with disabilities or with a chronic illness is exempt from the Secure Act, S-E-C-U-R-E. The Secure Act says that all healthy people who receive an inherited IRA must take the money out in 10 years and pay all the tax. Well, your loved one who is definitively defined as disabled by Social Security, basically, that person is exempt from the Secure Act. And if you didn't know that, that means that when you leave an IRA to the Supplemental Needs Trust, that Supplemental Needs Trust is also exempt. And we need to, in an ideal world, put specific language in that says this: when my loved one receives an IRA in his or her Supplemental Needs Trust, that Supplemental Needs Trust and my loved one are exempt, and my loved one can stretch out and defer the taxation over their entire lifetime according to the IRS tables, just like most beneficiaries could have done prior to 2020. But chronically ill people, disabled people, and 3 other types of individuals are exempt. So that's something that you really need to know about for those of you who are putting most of your assets into retirement plans. Of course, in a perfect world, what would we do? We wouldn't rely on retirement plans. We would all make sure that we were funding our Supplemental Needs Trust with life insurance, permanent life insurance, to make sure that there is a certain amount of money coming in to support our loved one, because none of us really know how much money we are going to have when we ultimately pass away. I just mentioned the Secure Act, so here are the 5 types of individuals or classes of individuals who are exempt under the Secure Act. And the Secure Act has gone through a reiteration called Secure 2.0, and that was earlier, several months ago, or more than a year ago. And we now know that the Secure Act is becoming more and more embedded in the law. It's not going away anytime soon. So we have to deal with it. And it just says that when an IRA comes into a supplemental needs trust that's properly drafted, the law says that the IRA funds can be minimized, meaning only the minimum distribution comes in, and that it can be accumulated inside the trust and used for the benefit of the disabled person. Or if the trustee needs more out of the IRA, then much more can be coming into the trust other than just the minimum distribution to be used for the benefit of the person. But the bottom line is the disabled person can stretch out those benefits and not have to pay all the tax in 10 years.
Steve, can we pause for a question?
Hello, Jeff.
All right, a good question. If a family member is the trust protector, what do they need to understand in order to exercise the listed powers? How is that level of understanding different from the situation in which they are named as trustee and hire a CPA to perform financial, tax, and reporting management of the trust?
That is a great question. Thank you. I would say what you're asking is, what is the role of a trust protector as opposed to the trustee in this sense? And I would say the way to think about it is the trustee has the primary fiduciary responsibility to invest the funds prudently, account for the funds, use the funds for the benefit of the beneficiary, and all of those fiduciary duties, as we're looking at here on this slide of concentric circles. The trust protector, on the other hand, is a special fiduciary that is given the power to do two primary things: to tell the trustee what to do with regard to amending the trust. So let's say that with Secure, let's say that there's a Secure 3.0 coming up. Well, if that changes the nature of the laws to such degree that the trust needs to be amended, then the trust protector has the right to amend the trust or to direct the trustee that the trust has to be amended. And let's say a lawyer drafted up a new amendment to the trust and so forth. So the trust protector has this fiduciary duty as well, but their authority is limited to whatever trust protector powers they have. So the trust protector can generally remove and replace trustees. They can also direct the trustee in certain ways that within their power. And one of those ways is to amend the trust. Or in the example I just gave, demand an accounting. If the trustee was not accounting, which many trustees don't do that today the way they used to. A lot of accountings don't get done, accountings don't get accepted, or they don't get created, I should say. And a lot of bank statements and other things are substituted for what would normally be an accounting, under the idea that accountings are expensive, so why should we do it? Well, a trust protector would at least have the authority to review the trust records and books. And I think these concentric circles here kind of epitomize what the perfect trustee would be. And Jeff looked hard for these photos. He thinks these are examples of perfect trustees, but in all seriousness, let's look at these circles. So the trustee of a special needs or supplemental needs trust has a higher level of duty, I would certainly think. And they want to advocate for the best interests of the beneficiary, understand public benefits, read the trust terms and provisions. And see, this is where, if you start with the proper platform, I think you can build certain features that if the trustee really understands this, they, through their understanding, can enhance the quality of the loved one's or the beneficiary's life. If for no other reason, then there's other things the trustee understands they can do for the benefit of the person, rather than a plain vanilla trust that might be just fine for the Maryland Discretionary Trust Act, but it doesn't educate the trustee as to what can be done. So the trust, in my view, not only is something that clearly shows it's discretionary and it exempts the person's assets from being an available resource, but it also educates anyone who reads it and tells them the scope of their authority and what they can do. The trustee has to be accountable and provide for accurate records and keep the beneficiary informed. Comply with statutory duties. For example, the beneficiary of the trust is entitled to information. They are entitled to notice. And of course, the trustee has the duty to invest the money prudently, understand taxes, and taxes as they relate to the trust administration, and of course, hire professionals. Unless the person is a professional themselves, They should not be attempting to do these fiduciary responsibilities without outside professional help. Many people ask, what can a supplemental needs trust or special needs trust pay for? Well, that's going to depend on what kind it is. If it's a third-party trust, there's really no practical limitation as long as it's for the benefit of the person with disabilities. Now, of course, the trustee has discretion over this. For a special needs trust of the D4A type, then there's going to be more of a defined list of what is acceptable, because that trust is considered to be a sole benefit trust versus the broader third-party trust. The D4C trust is going to have its own trustee of the pool, the nonprofit organization, and that trustee is going to be making decisions about what is the right thing to do as far as distributions. We talked about how much to fund into a trust. This is going to depend on the family. It's going to depend on the assets. It's going to depend on whether there's life insurance that's being used as a funding tool, whether that life insurance is permanent or term life insurance. And of course, ideally, even though it's very expensive, we would have permanent life insurance and of the kind that will not run out if we were to live to an old age. So we want to utilize financial advisory resources. If you don't have a good financial advisor or a life insurance professional or a team, we want to help you get that in place. We talked about the first party trust, how it is used in litigation, how it is used to house money that somebody might receive by inheritance, a personal injury award. These trusts are approved by the Attorney General, and these trusts are payback trusts. But in best practices, if you do not have a first party trust for your loved one now, and let's say that you don't anticipate you'll ever need one, well, arguably, it's still a best practice to establish one of these trusts, even if it's never going to be funded, so that you already have it in place just in case your loved one were to ever receive money they were not supposed to receive or shouldn't have received. And that vessel, that structure is there to go ahead and put that excess money in that needs to be moved out of your loved one's name. So if you ever want to put together a special needs trust of the D4A type, if for no other reason than to have it on standby, that is not a bad idea, and it's not costly to do that. So let's talk about what it takes to establish a trust. Well, it's a process, and I apologize in advance for this squiggly looking design. But really what it's trying to say is that there's a lot of energy going around there, starting with understanding what we're trying to do, having goals, and then basically as we go clockwise around this hurricane, we might call this tornado or whatever this process is here, we are going to be taking our time to sit and think. Think about incapacity planning for ourselves and for our loved ones. Think about the trust itself and all of these considerations, the financial aspects, and eventually get to a signing of the trust. But also you'll notice up in the left top, we're talking about a family meeting. Some people a lot of clients are very enthusiastic about a family meeting. When we educate you in your planning, many times we want to educate your fiduciaries. So for example, the nice person who asked the question about a trust protector, we would be educating not only the family who's doing planning, but the fiduciaries. We want to do that through a family meeting, whether that's by Zoom or in person. So you see, when we have the planning team in place and we are surrounding that planning team with a process of education, now we can get to where we want to be. We can be intentional, purposeful, and we can know why we're doing what we're doing. And that's why I initially talked to you about getting organized, not just to sit through the education today, but say to ourselves, how can we get organized, compartmentalize this information, prepare ourselves to receive information, and to enter into a process where the planning becomes its own reward. It becomes a reward by really saying, I put in the hard work, I put in the time, and I understand what I did and how it works. We talked about guardianship. Sometimes this is absolutely necessary. So I don't want to imply at all that guardianship, it can be always avoided. It cannot be avoided in many cases, Many of you have loved ones that are under guardianship, but we're living in a world now where there are more choices than we've ever had. So our traditional view is a person may need a guardian of their person or their property or of their estate. But now we have other things in the law, such as supported decision making, which has now started to shake out in the law. It's now being reviewed, it's being evaluated, it's being interpreted by courts. So remember, in this thinking, we've got a person on the left here who has a high capacity to be able to self-determine, and that person, let's say, could sign a financial power of attorney and advance directive. And in doing so, they've appointed an agent, and that agent basically is going to make decisions for them if they cannot do it themselves. They are keeping their self-determination. On the right-hand side, we have guardianship, the complete loss of self-determination, basically, and the antithesis of this capacity. So this is a person who is incapacitated for purposes of being able to make their decisions, and by definition, they need protection. In the middle, we have supported decision making, which is a concept that basically says, well, I'm going to make my decisions to whatever extent possible, provided that I have the support to do so. So somewhere on this continuum, we're going to decide in a counseling type of environment how to think about self-determination for our loved one with disabilities and whether a guardianship is needed or can it be avoided. So we want to encourage you to be proactive, think about yourself, think about your organization, not just your education, but your organization. We want you to create a memorandum. We want you to have your own estate plan, because you can't really do estate planning for a loved one with disabilities without a solid estate plan of your own, 99% of the time. You're going to want to think in terms of how you view a supplemental needs trust and how you think in terms of the design. Our job here at Elville & Associates is to give you a framework and really let you discover through a process of education the things that are important to you and things that we're going to juxtapose to you that we think are important. No trust is going to be good unless it's funded. So we want to think about what are the funding tools. Should we fund the trust with life insurance? Should we rely on assets that are going to come into the trust at our deaths, and so forth? And we want to understand, if we have retirement plans, which most of you do, how do those retirement plans relate to funding the special or supplemental needs trust based on the new provisions of the Secure Act? We want to make sure you and your trustees are educated about public benefits. Again, I recommend books like the one I mentioned earlier, How to Administer the Special Needs Trust, and the title says the California Special Needs Trust. Start using your vision that you may not be able to do at home. You may have to come into a quiet setting where you can have a counseling session and a series of discoveries, okay? Start thinking about those persons who are your fiduciaries, your trusted advisors, your advocates, okay? And again, learn how to create this supplemental needs trust or special needs trust, either inside of your own estate plan or on its own. So we have no-cost consultations to do this. We're going to encourage you to contact Jeff or contact my assistant Barbara or contact me at my contact information and set an appointment when you come in to talk about supplemental needs trust or special needs planning or guardianship or whatever issues are concerning to you. There's no loss of confidentiality. There is an attorney-client relationship, even if you don't eventually become a client or do further work with a law firm. So just know that there's nothing to fear. It's all confidential. If you haven't completed a special needs or estate planning questionnaire, please ask Jeff for one. And we want to see your current documents. If you have a current plan, generally we don't charge to review those. So we can look at it and give you kind of our thoughts on the structure of your current plan and what it might need as far as any changes or updates. We want to help you form that advisory team. If you don't have one, we've mentioned that several times so you can see how important I think that is. And we want you to prepare questions, and we love to answer your questions. It makes our meetings, it makes our webinars much better. And again, I mentioned several times, we want to give you the time to think, because we know many of you don't have a lot of time to think about these things. So I encourage you to get organized. You're already helping yourself by getting educated, and I thank you for your commitment for that. Jeff, I'm going to turn it back to you, and it looks like it's still raining, but we're into spring, and we're going to just go with it today and look forward to a very, very happy spring. I'll turn it over to you, Jeff, and I thank everyone for attending today.
Well, thanks very much, Steve. April showers bring May flowers, as they always say. So now would be a great time to get your final questions in. Thanks, Steve, for a great, comprehensive presentation. Always one of my favorites of the many that we offer here. So we have a couple questions here, and now would be a great time to get those final ones into Steve. And every question is a good question. This is a really great one, Steve.
Jeff, I think we have a little loss of audio on your end. It could be the weather.
Is that better? Steve, is that better?
Jeff, I apologize, Jeff. Can you hear me? We are having a little audio loss here. Jeff, I don't know if you can hear me. We've lost a little audio in the last minute.
Okay. Is that a little bit better, Steve? Oh, sounds like they can hear me.
Yes, I can hear you now. We lost your audio, and yes, I can hear you. Can you hear me?
Sounds like you might be a bit choppy here, Steve.
It looks like we have a loss of audio, and Jeff, I'm going to. Yes, I couldn't hear the question, and I don't know if you can hear me.
I can hear you with a little bit of a pause.
Okay. Well, I can hear you now, Jeff. If you can ask the question again, I couldn't hear.
All right, let's give this first question a try, and then we'll go from there. So the question is, how can I bring my high-performing loved one into this process in a way that is comfortable and empowering?
That's a great question. You can hear me. Thank you. Wonderful question. I would say if you have a high functioning loved one, please bring them to the meeting if you think it's appropriate, because we routinely have disabled children or loved ones come to meetings where appropriate, and we have very spacious place here, and they can feel comfortable. And then we can engage with them in whatever way you think is best during that meeting. And they can wait outside, they can be in the meeting itself. So we have a very comfortable kind of environment here for that. If you could hear me, I hope it came through.
So, okay, a little bit choppy on that one, Steve's end. I think we'll probably finish up here. We have one more question, Georgiana, and I'll go ahead and get that information directly over to you. And I'll just wrap up really briefly. I'm going to send out a message to everybody, as I always do, with all the information that Steve alluded to, including our links in today's video and Kevin Urbash's book, all the resources that Steve mentioned. So we appreciate your interest in Elville & Associates and our webinar series, and we look forward to seeing you again soon. I hope you have a safe and wonderful day.